La Cour
Be seated. I declare open the public hearing on the admissibility and merits of the case of Pindo Mulla against Spain. The application was lodged with the Court on the 13th of March 2020 under Article 34 of the Convention by an Ecuadorian national, Ms. Rosa Edelmira Pindo Mulla. The application was allocated to the fifth section of the Court pursuant to Rule 52, Paragraph 1 of the Rules of Court. It was communicated to the Government on the 16th of April 2021. On the 4th of July 2023, the Chamber decided to relinquish jurisdiction in favour of the Grand Chamber. There are two third parties in this case, the French Government and the European Association of Jehovah's Witnesses, who were granted leave by the President of the Grand Chamber to make written submissions in accordance with Article 36, Paragraph 2 of the Convention and Rule 44, Paragraph 3a of the Rules of Court. The respondent government are represented by their agent, Mr. Alfonso Brezmes Martínez de Villarreal, their co-agent, Ms. Ede Elena Nicolás Martínez, Mr. Francisco de Asís Sainz Gandasagui, counsel, and Ms. Francisca Molina Agea, Ms. Ángela Domínguez Bravo, and Mr. Francisco Reynoso Barbero, advisers. The applicant is represented by Mr. Peter Munsny and Mr. Shane H. Brady, counsel. They are assisted by Mr. David García Martín, counsel. I welcome the representatives of the parties in the name of the Court, as well as the applicant herself who is attending the hearing. I also welcome members of a delegation from the French Conseil d'État. Having consulted the agents of the government and the representatives of the applicant, I have determined the order of the address as follows. Ms. Nicolás Martínez will speak first, followed by Mr. Brezmes Martínez de Villarreal for the government, and then Mr. Musni, followed by Mr. Brady for the applicant. Ms. Nicolás Martínez, you have the floor.
Members of the Court, it is my honour to speak before the Grand Chamber and together with the agent, Mr. Brezmes, present our government's position to the case. On the 7th of June 2018, Ms. Pindo was transferred from a hospital in Soria to a hospital in Madrid. Her life was in serious danger and she needed immediate medical intervention. The doctors awaiting her at La Paz Hospital had been informed of the patient's condition of Jehovah's Witness and that in Soria she had refused blood transfusions. When the patient arrived at La Paz, her condition having worsened, they considered that the only way to save her life was to apply a surgical technique which required a blood transfusion. They took her to the operating room and in a very delicate and complex operation removed the tumor she was suffering, managed to overcome the bleeding and saved her life. Previously, while she was being transferred by an intensive care ambulance, the doctors in La Paz had warned the duty judge of the situation. With the information the duty judge had received, and given the lack of certainty about the patient's will, he authorized the application of the medical techniques which were needed to save the applicant's life. In the present case, the Court is called upon to determine whether the Spanish authorities' actions violated Articles 8 and 9 of the Convention. Two actions are at stake. the judicial decision to authorize the application of any life-saving medical treatment, and the actions of the doctors in La Paz, who, after examining the patient, decided to immediately intervene by applying the only technique that they found that could save the applicant's life in that moment, which involved a transfusion. The applicant claims that there has been a breach of the said articles. The government are convinced that in the context in which the events took place and given the specific circumstances of the case, the doctors could not be expected to act differently from the way they did, giving priority to the applicant's life. In this hearing, we will explain the reasons for our position, reasons which are set out in more detail in our written observations, to which we refer. I will address two issues. Firstly, the inadmissibility ground relating to the applicant's lack of diligence in the national proceedings. Secondly, I will comment on the delimitation of the object of debate and the facts of the case. The agent, Mr. Breathness, will then take the floor to address the merits of the case. I start by referring to the inadmissibility ground. The applicant appealed the decision taken by the duty judge, stating, among other reasons, that he had not taken into account that the applicant had previously expressed in writing her refusal to receive blood transfusions, despite being informed of the risks she was facing. She explained that on 6 June, she had stated her refusal to receive a blood transfusion in an informed consent document. With the appeal, the applicant submitted, among other documents, this IC document to which she was referring, but in the document submitted, the signature of the applicant was missing. This fact, for which she didn't give any explanation in the course of the proceedings, determined that the Audiencia Provincial dismissed her appeal, as they could not take into consideration a document which was not signed. Had the signed document been submitted, the court would have addressed the question of the relevance of the written refusal to the treatment specifically proposed by the doctors. The government considered that the applicant's lack of procedural diligence in the national proceedings renders the application inadmissible. I will now comment on the delimitation of the object of the debate and facts of the case. As said, the applicant is challenging two kinds of actions. The judicial decision to authorize the application of a life-saving medical treatment taken during the ambulance transfer, and the later actions of the La Paz medical team who intervened her when she arrived at the hospital. Regarding the judicial authorization, three aspects must be highlighted. First, the decision was taken in a context of great urgency. The judge assessing the information provided to him, which was the only information available to La Paz doctors in the time of their reporting to the judge. The situation required a very quick response, and the judge acted so. He immediately initiated pretrial proceedings and heard the forensic doctor and the public prosecutor. And after establishing that there was indeed a situation of serious and imminent danger to the patient's life, given the lack of absolute certainty with the elements that were available to know her clear will, he authorized the doctors to apply the medical treatment necessary to save her lives. All of this within a period of 1 hour. Secondly, it is important to highlight that the judicial decision was in nature not an order to the La Paz doctors to act by imposing a specific treatment on the patient, but an authorization for doctors allowing them to act in the way they would deem necessary if they found that this way was the only one that could save the patient's life. Thirdly, we must mention some inaccuracies in the communication from the doctors to the judge due to the hurry. For example, it was stated in that communication sent by fax that the fax was being sent by 3 anesthesiologists, when it was 2 anesthesiologists and 1 gynecologist. And it was also stated that the patient refused any treatment, when she in fact only refused a single treatment, blood transfusion. However, we believe these inaccuracies are not relevant, taking into consideration that the applicant only refused one treatment, but it was the treatment that could save her life, the blood transfusion. Regarding the actions of the La Paz medical team, we must go back to the time when the applicant, a patient at Soria, who had been admitted to the emergency unit the day before the incident due to a sudden worsening of a myoma, was transferred by an intensive care ambulance from Soria to Madrid. 3 aspects of this transfer should be stressed. First, the transfer was agreed with Mrs. Pindo because, given her clinical situation, her bleeding, the drastic reduction in hemoglobin values, the big size of the myoma and its evolution, in Soria Hospital it was indispensable to carry out a transfusion to operate on her. There was no possibility there to use an alternative technique without blood, such as artery embolization. Second, La Paz Hospital does have, like few public hospitals in Spain, specific means to carry out bloodless treatments, which are applied in some cases when there are medical reasons that make that transfusion inadvisable, or when patients refuse transfusion due to religious or other reasons, and the alternative treatment is viable. Third, this transfer meant that the patient would be treated in a hospital belonging to a different health service, given that in Spain, healthcare is decentralized in the autonomous communities, each one with its own health service, which they manage autonomously. The La Paz doctors, as already said, were aware of the patient's condition of Jehovah's Witnesses and the fact that in Soria she had refused a blood transfusion. They had also been informed of the existence of a high risk to the life of the patient who was being moved. However, they did not know the exact situation in which the applicant would arrive at La Paz, its severity, and her level of consciousness. They did not know whether a blood transfusion would be the only way to save her life. And for this reason, as a precautionary measure, they informed the duty judge of the situation with the information available to them at that time, asking him for indications. When the intensive care ambulance arrived at La Paz, Ms. Pindo was received in the emergency room. In her application to the court, she claimed that she arrived at 1 p.m. and she waited for 2 hours before being operated. In further submissions, her counsel has changed her narrative, sustaining that she arrived at the hospital not at 1 p.m., but 1 hour and a half later. Whichever the precise time at which Ms. Pindo arrived at La Paz, what is relevant is that in the moment she arrived, there was no waiting interval. As soon as she arrived at the hospital, she was received in the emergency unit. A series of tests were carried out, and after examining the results, Ms. Pindo herself, she was taken directly to the operating room to proceed with the operation. This is corroborated by Ms. Pindo's husband in his written statement provided with the application, in which he acknowledges that once in La Paz, she was examined and immediately went to the operating theater. Once having examined Ms. Pindo and the test results, the doctors in La Paz decided to act, taking into account 3 elements that we consider of a crucial importance. We have proved the concurrence of these 3 elements with several documentary and other kind of evidence, with special mention to the reports issued by the La Paz doctors who treated directly the applicant. The first one is that the situation in which the patient was in that moment was of extreme urgency, with imminent risk of death if immediate intervention was not taken. The second one is that when the applicant was examined by the doctors in La Paz, they realized that there was no possibility of applying an alternative bloodless treatment, namely embolization, even though La Paz Hospital is prepared for performing bloodless treatment in certain cases. They found that for medical reasons, in that moment, Ms. Pindo's life could only be saved if hysterectomy was carried out with a subsequent blood transfusion. And the third one is that given the applicant's situation and hemoglobin level on arrival at La Paz, although she was conscious, she could not reasonably be considered to have the cognitive capacity required to make a decision on her survival with a minimum guarantee of lucidity. The applicant has not challenged the actions of the doctors in any internal proceedings. She has not disputed before the national courts that the medical team acted in accordance with lex artis. She never filed any extrajudicial or judicial complaint for malpractice liability or a criminal complaint against the doctors. The applicant's counsel before this court has called into question different technical aspects of the actions of the doctors in La Paz. In particular, he disputes their assessment made of the three elements above mentioned and suggests malpractice on their part, providing two medical reports to that end. But this debate, we believe it's not appropriate before this court. If the court had to decide on these aspects, it would be acting as a first instance, because it would be examining issues that have not been raised in any domestic judicial proceedings. Therefore, when assessing the actions of the La Paz doctors, we must take as a starting point the situation that we have described and which we base on the direct appreciation of doctors who treated Ms. Pindo. Let me conclude this overview of the relevant facts of the case with a mention to the conduct of Ms. Pindo in La Paz. At no time, since the moment she arrived at La Paz until the operation began, did she communicate to any of the people who attended her, doctors or nurses, that she refused to receive a blood transfusion. She didn't ask anyone which treatment she was going to receive there, even though she could easily see that she was not entering an embolization room, a space which is clearly recognizable, especially for Jehovah's Witnesses, which have a deep knowledge of this kind of technique. She did not show or give any document to the doctors in La Paz, expressing her opposition to receive a blood transfusion, nor did she even inform them verbally that she had signed and registered advance directive. She states that she didn't mention her will nor showed any document because she had taken it for granted that she would not receive the blood transfusion because she had made it very clear in Soria through various channels. However, she was no longer in Soria. She was in La Paz, a hospital of a different health system with a different medical team whom the complainant had not met before. I pass the floor to Mr. Brefnes. Thank you.
Thank you very much. Mr. Brefnes Martinez de Villarreal, you have the floor.
Madam President, distinguished members of the court, representatives of the applicant, it is my honor to present, together with my colleague, my government's opinion on this case. And it is particularly fortunate to count today with the applicant, Mrs. Pindo Mulla, whose presence here is possible thanks to the intervention of the national medical authorities who saved her life. The court has already held that the refusal of blood transfusions by Jehovah's Witnesses falls within the principles of self-determination and personal autonomy protected by Articles 8 and 9 in Jehovah's Witnesses of Moscow versus Russia and in Taganrog LRO versus Russia, even if it can result in death. However, these two judgments refer to the prohibition by the Russian authorities of the Jehovah's Witnesses Church, but they did not concern an individual dispute involving a Jehovah's Witness who had undergone a blood transfusion against her will, as is the present case. As regards national case law, our Constitutional Court has also ruled on the right to be informed and to decide freely on medical interventions, echoing the Court's doctrine, concluding that the patient has the right to prevent any non-consensual intervention on his own body. Also, national practice reveals that in ordinary conditions, a free and fully lucid refusal to a treatment is respected by Spanish hospitals. La Paz is, in fact, one of the leading hospitals in Spain in searching alternative treatments to blood transfusions. What is at stake actually here today is a case with very specific peculiarities which request the Court to decide the conformity with the conventional system of the response given from the national authorities faced with a situation of extraordinary urgency where it was not possible to follow the ordinary protocols in order to ascertain the patient's will. For the sake of clarity, my submission will now address the following matters. Firstly, I will address the three main issues behind this case: patient's personal autonomy and informed consent, urgency situations, and advanced medical instructions. Secondly, I will address an exam of the rights at stake. And thirdly, I will conclude presenting my government's conclusions on the present case. Regarding patient's personal autonomy and informed consent, Article 5 of the Oviedo Convention stresses the need for free and informed consent prior to any intervention in the field of health. As France has outlined in its third-party intervention, a national legislation that requires that patients are fully informed of the various treatments available or the inexistence of a treatment that avoids a blood transfusion is a guarantee that they will be able to express free and informed consent. This is the case of the Spanish Law 41/2002 on patient autonomy, Article 8. In fact, Spanish law goes beyond the Oviedo Convention, requiring the informed consent to be given in writing as an additional guarantee. This is what the Court precisely concluded in Reyes Jimenez versus Spain, in which our country was condemned precisely because the consent had been given only orally and not in writing. Descending to the applicant's previous refusal to receive blood transfusion, even if they could lead to death, I am sure that all of us who are attending this hearing today may agree that this is such a vital decision that it has to be absolutely free from any external pressure. However, in the present case, the informed consents made by Ms. Pindo Mulla in Soria rejecting blood transfusions had not been done alone, but in the presence of her husband and the elder, a very high and very respected representative of the Jehovah's Witnesses Church. Secondly, and even more important, those informed consents were issued in Soria, a different hospital from the one that finally attended her through its emergency services in a vital risk situation, and those informed consents weren't shown by her at La Paz Hospital. Urgency situations. Oviedo Convention recognizes in its Article 8 the right to intervene medically on a person whose consent or refusal to a treatment cannot be assured, therefore prioritizing their right to life. The Spanish law on patient autonomy, in its Article 9, also allows practitioners to carry out clinical interventions when there is an immediate serious risk to the physical integrity of the patient and it is not possible to obtain their authorization. In consequence, and answering the Court's question, life-saving interventions can be performed without an informed consent in situations of extreme urgency. In the present case, a vital risk situation was presented to the medical emergency unit of La Paz Hospital. It is worth noting that this vital risk was accepted by Ms. Pindo Mulla in all her submissions before the national courts. It is only after before this court that the councils now surprisingly dispute that urgency. Regarding advanced medical instructions, after establishing the Oviedo Convention in its Article 8, the emergency exception already mentioned, its Article 9 determines that previously expressed wishes concerning a medical intervention by a patient who, at the time of the intervention, is not in a state to express their wishes shall be taken into account. But, distinguished judges, decisions that refer to life are not written in stone, and its holder of this absolute right retains the right to override them after. Even more, when coming to analyze advanced medical directives based on religious or other convictions, the considerable group pressure which a person belonging to a group may undergo enhances the need to check those previous decisions at the crucial moment. If that check cannot be done because of the urgency of the situation and existing doubts on the free consciousness and will of the patient, as happened in this case, a conflict between different rights at stake arises, and medical national authorities have to use their margin of appreciation in order to decide. I will now address the exam of the rights at stake. Article 2 of the Convention. The Court has set a very high standard of proof to allow to end one's own life, which requires the incumbent state to put in place special mechanisms in order to guarantee that that decision has been taken without external pressures, duly informed, and with full awareness. In Lambert versus France, the Court concluded that the right to life implies also the need to take the necessary measures to protect the life of persons under its jurisdiction. This is indeed a positive obligation for the incumbent states. In Pretty versus UK, held that states are obliged to establish procedures to ensure that a decision to end one's life, euthanasia, is taken freely and in full knowledge of facts. To such an extent, Spain respects the autonomy of individuals in a medical field that in 2021 euthanasia was regulated, making Spain a pioneer country in this field. This right is nevertheless surrounded by a big number of measures to guarantee that the will of the person is clear and not influenced by external pressures. The existence of a double application with a time interval between the two of them, a deliberative process between the doctor and the patient, a medical report issued by a different doctor, as well as the constitution of a guarantee and evaluation commission to analyse each case. Therefore, a previous vital decision which can end in a person's death cannot be exempted from all the guarantees requested for the Court in its case law on euthanasia or other situations where life is compromised. In consequence, and answering the question of the Court, yes, public policy makers do consider and take into account the protection of life as a main task when balancing with the personal autonomy of the patient. Regarding Article 8, the Court recognises that states may interfere with the right to respect for private and family life of individuals as long as such interference is provided for by law, is necessary in a democratic society. In Haas, the Court admits an individual right to decide by what means and at what point his or her life will end, protected by Article 8, provided they are capable of freely reaching a decision on this question and acting in consequence. In Fabrica, concluded that there had been no violation of Article 8 since there was no consensus among the member states on a single model for child vaccination, so the states enjoyed a wider margin of appreciation. Regarding Article 9, and contrary to what it may seem, religious freedom does not play a key role in this case. The decision of any person who in ordinary conditions refuses a treatment, any treatment, including a blood transfusion, must be respected, be the reasons religious or not. The case would be the same if an atheist today had rejected the blood transfusion because they thought that diseases are transmitted through others' blood. After examining the rights at stake, and in order to answer other questions posed by the Court, it is necessary to outline the specific circumstances that concurred. First, the applicant had been transferred with her consent in an intensive care ambulance from one hospital belonging to a different local public administration in order to assess alternative treatment avoiding blood transfusion. Secondly, during that trip, a vital risk was alerted, so the medical authorities at La Paz Hospital asked the Court not to authorize them to do the blood transfusion, but to give them leave to decide within their margin of appreciation in order to assess the patient's health and lucidity at the moment of her arrival. Third, the judge did not impose but authorize any treatment necessary to save the life after consulting the forensic doctor and the public prosecutor. Fourth, that vital risk was confirmed by the clinical analysis when she arrived to La Paz, so there was no time, nor was the patient sufficiently lucid due to the massive blood loss to follow ordinary protocols with sufficient guarantees to confirm or not her previous rejections to blood transfusions. In any case, Ms. Pindo Mulla never expressed her rejection to a blood transfusion or the existence of her advance directive since she arrived to La Paz Hospital. I will now present my government conclusions on the case. First, Spanish legislation and case law respect the free and conscious decision of a patient not to undergo a specific treatment, even when it involves a risk to life. Secondly, only in the event that such consent cannot be obtained with the necessary guarantees in a situation of extreme urgency, can vital treatment be adopted in accordance with the emergency exception provided for in Article 8 of the Oviedo Convention. As the French government says in its third-party intervention, this allows the national authorities a reasonably wide margin of appreciation in order to assess all the concurring circumstances and make a fair balance of the rights at stake, ultimately prevailing life over the other rights of the patient when that assessment cannot be properly done. In the present case, the practice of La Paz practitioners was never contested by the applicant's lawyer before the national courts. However, unsurprisingly, the new counsels of Ms. Pindo Mulla before the court had contested that medical practice, which makes that we have to enter, and the Grand Chamber has to enter in that considerations. Without exhausting domestic remedies, and therefore having deprived our domestic judges to revise it, against the principle of subsidiarity, which is a cornerstone of the whole conventional system, and providing to the court with ex parte and ex post facto reports obviously done pro domo sua, as the Latin saying, in their own interest. My government therefore considered that the national authorities made a proper and prudent balance of the rights at stake in the given circumstances. The interference with the applicant's rights envisaged in Articles 8 and 9 was in accordance with the Oviedo Convention and the national law, and it pursued a legitimate aim and was necessary in a democratic society, being proportional in order to prevail the right to life of Ms. Pindo Mulla in the concurring circumstances. Distinguished judges, Madam President, common sense is the main tool of interpretation available to human beings. Grand Chamber judgments play a crucial role in the interpretation of the Convention, preventing that very specific cases introduce a disruptive element that prevents from a clear vision for the national authorities who ultimately have to implement the Convention. After my intervention, you will listen to the question of the applicant lawyers. What more has a Jehovah's Witness to do to avoid a blood transfusion? But the quick question is, which is the level of certainty regarding the patient's will required for the right of autonomy to prevail over the right to life? I cannot avoid to ask myself, who would win in case of a condemnatory judgment? The applicant, with a moral win declaring that she should have been left die at the hospital? Or the Jehovah's Witnesses Church? I also ask myself, would I have acted differently from what the judge and the doctors did? After studying carefully the case, my answer is still no. Distinguished judges, after we all leave this room, you will have to assess the message you want to send to the health authorities who dedicate their lives to save other people's lives in very urgent and difficult situations. I honestly think it would be a bad result for the whole system of the Convention to introduce a bias that can lead medical teams to avoid treatment for specific groups or avoid doing blood transfusions to certain people simply because they belong to a religious group without ascertaining their real will at the decisive moment. For all the reasons set out orally today and in our written observations, the Spanish government invites the court to declare the application inadmissible or subsidiarily dismiss it, finding no violation of the Convention. Thank you very much for your kind attention.
Thanks to the representatives of the Spanish government. I turn now to those of the applicant and call Mr. Musni. You have the floor.
Madam President, honorable judges, the surgeon must not be afraid to lie if this benefits the patient. This is a quote from Henri de Mondeville, personal surgeon of the King Philip le Bel, 14th century. This is called medical paternalism. The doctor knows best. No need for proper communication with the patient because eventually the doctor decides. Most countries around the world have tried to get rid of medical paternalism, but still, in 2024, there are some doctors who behave this way. Why? Because some doctors still view patients as medically ignorant. And Ms. Pindo was viewed as such, a vulnerable patient. Ms. Pindo is a vulnerable patient, could be perceived as such. Ms. Pindo is a South American immigrant who speaks Spanish with an Ecuadorian accent. Ms. Pindo is a woman, a small woman. And Ms. Pindo is one of Jehovah's Witnesses, a religion oftentimes subject to prejudice and stereotypes. Yes, Ms. Pindo was an easy target to medical paternalism. Now, during these few minutes, I would like to first show you how Ms. Pindo was the victim of medical paternalism. Two, I will show you the legal antidote you have in your hands to resolve such a matter. Three, we see how the domestic courts, instead of protecting Ms. Pindo's rights, have actually promoted medical paternalism. And four, my learned colleague, Mr. Brady, will address the government's arguments that continues to support medical paternalism, as you've just heard. One, first point. Ms. Pindo was a victim of medical paternalism. Is this just a fault? Well, please see the fact. Ms. Pindo is a decisive woman with a clear conviction, a personal, Bible-based conviction, no blood. And she has made that clear at least on 6 different occasions with doctors from Soraya and La Paz. One, and if you can turn to the binder that was provided to you. On page 1 of that binder, you see the durable power of attorney of Ms. Pindo, that Ms. Pindo has been carrying out for more than 20 years in her purse at all times, and which mentions, I do not accept transfusions, and she adds, even if healthcare providers feel that such are necessary to preserve my life. Acts 15, 28, 29. When Ms. Pindo is diagnosed in 2017 with her uterine myoma, what does she do? Well, she first goes to the regional registrar of Castilla and Leon to have her advanced medical directive, no blood, registered in the national database. You find that advanced medical directive at pages 3, 4, and 5. And you find at page 5 the name of 2 legal representatives with their phone numbers. And Ms. Pindo, she does that because according to the instructions of the national database, which you find at page 7, it says it can be expeditiously accessed and enforced by physicians when needed. So Ms. Pindo, she does her job. She feels safe. She feels secure. Her will be respected in the national database. On June the 6th, 2018, she is admitted to the Soraya hospital. And the next day she speaks with a doctor. And following that discussion, the doctor in Soraya writes, you have that at page 8 of the binder, and I read, the patient, for religious reasons, Jehovah's Witness, does not wish to be transfused under any circumstances. And he adds, she consciously refuses any transfusion. Consciously. She's lucid. He knows that. Fully aware. 4.7 grams per deciliter. Very low hemoglobin level, but she consciously refuses. 4, the same day, a second doctor in Soraya speaks with her, and he writes, in the medical record, it's written here, we propose blood transfusion, but the patient refuses. 5, she adds in the next sentence, signs informed consent, indicating that she does not accept blood transfusion, Jehovah's Witness patient. Yes, the doctor acknowledges that she had signed the informed consent form. There is no doubt about it. 6. Ms. Pindo is transferred from Soraya Hospital to the La Paz Hospital. And during the transfer, there is a conversation over the phone with one of the doctors in La Paz. And she repeats her refusal of blood transfusion. And this is confirmed in the latest interview provided by the government to the Grand Chamber. You have it at page 11 of the binder. The doctors from La Paz, they write, she was a Jehovah's Witness and refused the transfusion. They called us when the transfer was beginning. So, that makes not 1, not 2, but 6 repeated refusals of blood transfusions. And that raises a simple question. What else was Ms. Pindo expected to do more for the doctors in La Paz to respect her will? The government alleges that the doctors in La Paz did not know what was Ms. Pindo's will. Well, that's false. First, we just said they knew. They spoke to her over the phone during the transfer by ambulance. 2, and you have it still in the binder, they received the medical record before the surgery, page 12, attached medical record proposal for the referral of the patient, severe anemia, Jehovah's Witness. 3, they themselves, the doctors in La Paz, they write in the medical record, you have it at page 13, since the patient does not accept transfusion of blood products, it is decided to call the judge on duty to assess the case. They know. And even more, they continue in the medical record, page 14. Patient does not authorize transfusion of blood products. And they repeated the second time. Patient does not authorize transfusion of blood products. This was crystal clear. The government also alleges that Ms. Pindo was not fully competent. But that's false. No doctor and no judge at the time of the case before the domestic courts had any doubt about Ms. Pindo's full mental capacity. The Court of Appeal repeats twice that she clearly knew she was conscious and well aware of the situation. The doctors in La Paz, they knew her position. But what do? Instead, they seek an ex parte order from the judge to impose their medical treatment, their will, on the patient. And when they receive an hour later the facts, the decision from the duty judge, what do? They keep it secret. Plain medical paternalism. They don't speak with Ms. Pindo when she arrives to the hospital, don't inform her about it. Can you imagine, for a second, Ms. Pindo heading to a seemingly cooperative hospital, trusting that the doctors will respect her will, while the very same doctors are acting behind her back, and then they force a treatment that she abhors. The next day, she wakes up, and the next day she learns that the very treatment she abhors, the very treatment she has so many times refused, was imposed on her. This is what she says in her affidavit before the Constitutional Court, page 15. I started to cry. I felt outraged, raped. Although I try to forget that moment, I am not able to. It will always be on my mind. Such a thing cannot be forgotten. I feel hurt, broken, deeply saddened, and distressed, depressed. Now, your court has a legal antidote to resolve such matters so that it never happens again. That's the second point, the legal antidote. And this antidote is a ruling of principle that no doctor can force a medical treatment on a competent patient who has clearly expressed his or her will. And for that, please, let's have a specific focus, especially after what we heard from the government. This case, this specific case, is not to be confused with end-of-life treatment cases. This is not to be confused. Ms. Pindo wanted to live. She did not want to die. She wanted to be treated in accordance with her conscience. So this case is different from Mortier versus Belgium or Karzai versus Hungary, or Lambert versus France. And this case is also not to be confused with medical treatment involving third-party interest, such as vaccination campaigns or forced treatment on persons deprived of liberty, hunger strikes. There was no public health policy or rights of others to be balanced with Ms. Pindo's decision. Ms. Pindo's decision concerned only herself, her body, her conscience, no impact elsewhere. In such specific circumstances, there is one rule: the prohibition of forced medical treatment on a free and competent patient. And for that, I would like to lead you briefly through the ethical and legal reasons that support this rule. The ethical reasons. Your court has many times stated that the very essence of the Convention is respect for human dignity and human freedom. Human dignity and human freedom. The distinctive characteristics of us all as humans, our capacity of reasoning, our discernment, our conscience, that makes us masters of our own body. State authorities may promote a better health, eat 5 fruits and vegetables per day, not to smoke, exercise regularly, but they cannot impose such choices on us because we are the masters of our own body. We decide, whatever the consequences. Dignity and autonomy give proper meaning to life, because life is more than breathing. Life is breathing in harmony with one conscience. And that is why our societies salute the bravery of people such as firefighters, soldiers, policemen, who are ready to sacrifice their lives for higher values than life itself, for freedom. And the same applies in medical treatment cases. Survival is not always the highest value. Otherwise, doctors could force any patient with cancer a chemotherapy just for the sake of survival. Nobody of us would like that. Never. These ethical principles, dignity and autonomy, can be translated in the legal field into the right of self-determination. That's the second aspect, the legal point. Consider the tremendous work accomplished by the European Association of Jehovah's Witnesses, the third-party intervener, which has gathered dozens of Supreme Court decisions worldwide on all continents, common law, continental law, all of them that recognize the absolute right to self-determination for a competent patient. And you see also that 41 out of 46 states of the Council of Europe have established a clear legislation that does not allow to override a patient's will under any circumstances. 41 out of 46, that makes 90% of member states. Well, in view of such a strong consensus, common denominator, there can hardly be any margin of appreciation left to any contracting party that would oppose that absolute rule. And your own case law. YF versus Turkey, Glass versus United Kingdom, Jehovah's Witnesses in Moscow versus Russia, Soares de Mello versus Portugal, VC versus Slovakia, and more recently Taganrog LRO versus Russia, or YP versus Russia. They have all made clear that the imposition of a medical treatment, and I quote your court, is incompatible with respect for human freedom and dignity, which constitute one of the core principles of the Convention. But instead of recognizing that right and protecting Ms. Pindo's right, the domestic courts have actually promoted medical paternalism. That's my third point. The domestic courts' legal paternalism. We have here 3 decisions from domestic courts, and we focus on that because that's the case. The first, the duty judge, the ex parte order. The duty judge, she does not even know the identity of the patient, but she does not care. She could have checked just one phone call to the ambulance, to the Soraya hospital, to her legal representatives. No. Ms. Pindo is conscious all the time. She's there. She can speak. No. Instead, the duty judge just blindly trusts the 3-sentence-long report from the doctors in La Paz who have never clinically examined Ms. Pindo, never seen her, never spoken to her in depth, never examined her, and who simply state she refuses all type of treatment and she is massively bleeding. That's false. The second problem here, the duty judge orders to override the patient's will by using a 40-year-old outdated case law from Spanish courts that equates the right to life with an obligation to live. Well, in the most recent decision of the Constitutional Court, 22nd March 2023, 19/23, at page 71, the Constitutional Court itself states it would be absurd to equate the right to life with an obligation to live. Well, the duty judge did that and said this trumps her right to self-determination and freedom of religion. And third problem, the duty judge orders or gives carte blanche to doctors to impose any treatment they want on the patient, just to save her life. Ms. Pindo has now become an object, a broken object in the doctor's hands to do with her what they wish, just to survive at all cost. Plain medical paternalism. Second, the same duty judge, a month later, now that the treatment has been forced on her, the same judge justifies the forcing of the treatment by using another motivation. The judge affirms that she does not know, and I quote, whose is the signature on Ms. Pindo's medical directive registered by the authorities. In other words, the judge questions an officially registered advanced medical directive, but the law itself states it cannot be doubted. That leaves speechless. Third, the Audiencia Provincial, the Court of Appeal, uses now a new set of arguments to reject Ms. Pindo's appeal. The court considers that the doctors could not know what was Ms. Pindo's will because her signature was not found on one of the documents in the file. Well, this argument is false, it is formalistic, and it is excessive. It is false because Ms. Pindo had signed that document. And we read just before what the gynecologist in Soraya wrote. He said, patient signs informed consent indicating that she does not accept blood transfusion. This is prima facie evidence. It's there. If the judge had a doubt about that, she should have checked with the records that was retained by the hospital in Soria. Ms. Pindo was provided that document, only one document. This argument is also formalistic because the court focuses on just one seeming defect in just one document, while ignoring at the same time the overwhelming evidence that Ms. Pindo had expressed both orally and in writing that she refused blood transfusions, that the doctors knew her will, and that if they had a doubt, they didn't, they could have checked with her. This argument is also excessive, because what the Spanish law 41/2002 requires is that the will of the patient be recorded, or as the government itself states in its latest observation at paragraph 51, and they write in French, I quote a paraphrase in French, there should be une trace écrite du refus de traitement. Une trace écrite du refus de traitement. Well, there was more than enough trace écrite du refus de traitement all throughout the medical record that the judges had at hand. So you see, this is how legal paternalism came in support of medical paternalism. Both doctors and judges knew Ms. Pindo's will, but they treated her like an object. Madam President, honorable judges, you now have the opportunity to confirm your case law for the sake of legal certainty. No doctors can be allowed to force an unwanted treatment on a patient who has clearly expressed his or her will orally or in writing through advanced medical directive. Please, no more medical rape authorized by courts. I believe this is enough for you to conclude the violations of Articles 8 and 9 of the Convention. But because the government continues to promote, to support medical paternalism, my learned colleague, Mr. Brady, will now address the government's arguments. Thank you for your attention.
Thank you, Mr. Musni. Mr. Brady, you have the floor.
Madam President, honourable judges, the government makes three main arguments that are permeated with medical paternalism and legal paternalism, as we've just heard. They claim, first of all, that a refusal of treatment for it to be legally effective must be in writing and signed by the patient. Secondly, they allege that on the day of, the applicant's medical condition was a life-threatening emergency. And third, they allege there was no time for the La Paz doctors to have spoken with Ms. Pindo. We submit those arguments should be rejected. They have no merit, and we'll address each in turn. First, the argument that refusal of treatment must be in writing and signed to be effective. In making that argument, the government is confusing refusal of a treatment with consent to treatment. As my colleague, Professor Musni, has explained, for refusal of treatment, domestic law merely stipulates that there should be a written mention of that refusal in the medical records. It's an administrative task for the medical staff, not for the applicant, and it is certainly not a legal precondition to the patient's refusal being respected. As this Court has made so clear, treatment cannot be given to a mentally competent patient without her consent. In effect, the treatment door is closed and locked, and only the competent patient can choose to open that door by her express consent. When it came to blood transfusions, not only was the treatment door closed and locked, but Ms. Pindo had bolted it shut by 4 additional locks that we've heard of. First, her signed durable power of attorney that she kept in her purse at all times, by her signed advance medical directive, which she registered in the National Registry for exactly this purpose, by her repeated oral refusals of blood transfusions at the Soraya Hospital on June 5th and 6th, which were also recorded, written by the doctors in the medical chart, and also by that informed consent document that both she and the treating gynecologist signed at midnight on June 6th. Her refusal of blood transfusions was both oral and recorded in writing. But even if her refusal was only oral, that was more than sufficient to keep the treatment door closed and locked. Because the La Paz doctors admit, and we've heard it today, they admit that when they agreed to accept the applicant's care the morning, hours before, the morning of June 7th, they knew she was one of Jehovah's Witnesses, and they knew she refused blood transfusions. Her no meant no. The door was closed and locked, and it bound both the treating doctors and the domestic courts. Well, that brings me to the second argument raised by the government, the claim that the applicant's condition was a life-threatening emergency on June 7th. Well, our submission that argument is just simply irrelevant. We could just skip over it, because your case law has made so clear that a mentally competent patient can refuse any treatment, even in a life-threatening emergency. But because the government spends so much time on this issue, I'd like to just spend a few minutes to show from the contemporaneous hospital records that there was no life-threatening emergency. And if I could direct the Court to the binder in front of you, page 19. Page 19 are the records of the Soraya Hospital on June 7th. And we know from the note of the consulting hematologist that he confirmed that by the morning of June 7th, they had given tranexamic acid to Ms. Pindo to stop the bleeding. It was indeed effective, as he said. And then picking up at page 19, at the bottom of the page, you'll note the record says at 7:40 a.m. on June 7th, BP, blood pressure, HR, heart rate maintained, now little bleeding. And then going up the page on page 19, at 9:14 a.m., 2 hours later, no bleeding, blood pressure maintained. Further up the page, at 12:12 p.m., 3 hours later, vital signs maintained, no bleeding. Well, at this point, the applicant is transferred from the Soraya Hospital to the La Paz Hospital by ambulance, and you'll see those records at page 20. This is the ambulance record. And you'll note that the transfer near the bottom of the page, it shows it took place between 12:22 p.m. through to 2:20 p.m. And the doctor in the ambulance writes, conscious, oriented, and cooperative patient with bleeding less than that of a menstrual period. We continue. She's now taken to the La Paz Hospital. She arrives at approximately 2:20. As the government admits, there was a series of diagnostic tests when she arrived, blood pressure tests. She received an ultrasound. At 3 p.m., she's taken up to the operating room, and you'll find that record at page 21. And the records, the contemporaneous day of records, write, the patient goes to the operating room stable hemodynamics, conscious and oriented, Glasgow, that's the Glasgow Coma Scale, 15 out of 15, indicating she is fully lucid, fully alert, fully conscious. And as my colleague has just mentioned, the Court of Appeal twice repeats that. Page 108 of our submissions, the Court of Appeal confirms she was fully alert and conscious on the day of. That was never challenged in the domestic courts. And it continues, slight bleeding. Well, what about her hemoglobin level, the level of her circulating red cells? Just above where I read, you note that on the morning of, at 7 in the morning, her hemoglobin was 4.7 grams per liter. What was it 8 hours later, just prior to the surgery? Well, you'll see that on the next page, page 22. At 3:02 p.m., her hemoglobin was now 5.5 grams per liter, showing that it was unchanged during that 8-hour period, or even slightly higher, indicating no ongoing bleeding, certainly no ongoing hemorrhage, as the government alleges. And then finally, what was the level of the transfer? What was the urgency of the transfer? Well, again, the contemporaneous records, page 23, record that the level of the ambulance transfer was recorded as normal for the 2-hour transfer between Soraya and La Paz. This is also confirmed by 2 independent medical expert opinions. Beginning at page 24 is the opinion of Professor Zakharowski, who is the director of the Department of Anesthesiology at the Frankfurt University Hospital in Germany. He's also a representative to the European Union for the European Society of Anesthesiology and Intensive Care. He's one of the leading experts worldwide in patient blood management, which I'll come to in a moment. And as far as his opinion in this case, page 27 of the materials, right at the top of the page, he concludes that Ms. Pindo Mulla's medical condition was stable in the hours leading up to the surgery on June 7th. And then further, under heading C, there was no urgent medical need for the surgery to start at 3:10 p.m. The second expert, page 30 of the materials, this is Dr. Duque, a specialist in anesthesiology in Turin, Italy. She likewise concludes the patient was hemodynamically stable at all times, as shown in the transfer sheet, that ambulance transfer sheet we've looked at. The patient's vital signs exclude the presence of immediate life-threatening conditions. The patient was not suffering hemorrhagic shock. The contemporaneous medical evidence, contemporaneous medical chart, supported by the opinions I've just looked at, confirmed there was no life-threatening emergency on June 7th. And both experts also confirmed that the applicant could have been treated in harmony with her religious conscience. And just to conclude on that, Professor Zakharowski notes at page 27 of the materials in front of you, the binder, right at the bottom, Ms. Pindo Mulla's condition could have been appropriately managed without blood transfusions on June 7th by applying the 3 well-known and widely accepted pillars of PBM, patient blood management. In his opinion, he explains that patient blood management is the medical standard recommended worldwide by the World Health Organization, also the European Commission, and he notes, actually the World Health Organization notes, as he quotes, that PBM improves patient outcomes and improves patient safety. But that brings me to the last argument that the government raises, their claim that there was no time for the La Paz doctors to have spoken with the applicant or to consult her advanced medical directive. Well, it begs the question, how much time did they need for that discussion? They had more than 4 hours and 12 minutes, more than 4 hours and 12 minutes for that discussion. That period began at 10:58 in the morning, and you'll see the government's admitted this. We have it reproduced also at pages 31 and 32 of the materials. The government admits that at 10:58 a.m., when the ambulance was called, they knew by that time that the applicant was one of Jehovah's Witnesses and she refused transfusions. And that period lasted all the way to 3:10 p.m. when the operation took place. Well, what could the La Paz doctors have done during that 4-hour and 12-minute period? Well, the obvious is they could have spoken to her. They could have picked up a telephone and called her when she was at the Soraya hospital and spoken to her about her refusal of transfusions. Or during that 2-hour ambulance transfer, they could have spoken to her in the ambulance. We know, and the parties agree, that after the ambulance left the Soraya hospital, there was a telephone call between the ambulance and the La Paz doctors. So if the doctors had any doubts, they could have called back and spoken to the applicant, who was conscious, oriented, and lucid, as all of the records confirm. Or after she arrived at the La Paz hospital at 2:20, they could have spoken to her then, when, as we know, these other tests were taking place. Or at the very latest, they could have spoken to her at 3 p.m. when she was brought up to the operating room. How much time would that discussion have taken or required? Well, Professor Zakharowski makes the common sense conclusion at page 25 of the materials in front of you. Right at the bottom, we've highlighted, he concludes the entire process, that discussion, could have been completed in a few minutes. What else could the La Paz doctors have done during that 4 hours and 12 minutes? Well, they could have talked to the Soraya doctors, who had had in-depth discussions just a few hours before with the applicant about a refusal of transfusions. Or they could have consulted her advanced medical directive, which was registered in the National Registry for exactly this purpose. Or they could have spoken to her appointed healthcare representatives. Their telephone numbers and names were right on the advanced directive. The doctors had 4 hours, at least 4 hours and 12 minutes to have spoken with the applicant if they had any doubts about her refusal of transfusions, or to consult her AMD, her advanced medical directive. In reality, they had no doubts. To conclude our submissions, in Lambert versus France, the Grand Chamber stressed at paragraph 178 that it is the patient who is the principal party in the decision-making process and whose consent must remain at its heart. For the duty judge, and for that matter for the La Paz doctors, the applicant was not a party. She wasn't even a spectator. The proceedings were ex parte. The applicant's refusal of transfusion was overridden based solely on a 3-sentence fax of the La Paz doctors, who had not even seen the applicant. And in the subsequent domestic proceedings, she was never heard. This was blatant medical and legal paternalism. Because the applicant's refusal of blood transfusions did not impact public health or the rights of others, we invite this Grand Chamber to conclude that her refusal was an absolute right, not subject to state justification under Articles 8.2 or 9.2 of the Convention. And this is the approach taken by Supreme Courts throughout Europe and internationally, as set out in Annex 2 of the submissions of the European Association. And finally, to prevent similar violations, the applicant also invites this Grand Chamber to confirm the Court's long-standing case law under Articles 8 and 9 of the Convention, and rule that a mentally competent patient has the absolute right to refuse any recommended surgery or treatment, even if that surgery or treatment is considered medically essential. The competent patient's no must mean no. Madam President, honorable judges, this case presents your Grand Chamber with the opportunity to issue a milestone judgment on the patient's right to self-determination, a judgment that can provide legal certainty and improve doctor-patient communication to the benefit of all patients and doctors in Europe. Thank you. Those are our submissions.
I thank both parties for their submissions and now turn to the judges of the Grand Chamber to see if they would like to pose questions. Judge Sieber, 4.
Thank you very much, Madam President, and I thank the representatives of the government as well as of the applicant. I would like to seek some clarification about the remedies available to the applicant. My questions are addressed to both parties. The applicant is arguing inter alia that the doctors in La Paz Hospital failed to protect the applicant's autonomy. Yet, as we have heard from the representatives of the government, the applicant has only pursued judicial proceedings against the auto, not against the doctors. Therefore, my first question is as follows. Could the applicant have brought proceedings against the doctors or against the hospitals of La Paz or Soria? If so, why did she limit herself to challenging the auto? I wonder whether such proceedings could have led to a clarification of the facts which are now disputed in the party submissions to our court, such as, for example, the applicant's capacity to consciously refuse blood transfusion at the time that she arrived at the La Paz hospital, whether there were alternatives available in the current state of health, what information was available to the La Paz hospital doctors, and whether they would have been able to access the national registry. All these issues are being pleaded controversially, and I wonder whether clarification could have been sought by resort to the domestic remedies. Now, secondly, turning to the applicant's application to annul the auto, I would like to seek clarification on which factual basis the auto could have been annulled. Could it have been annulled on the basis of insufficient information provided by the La Paz doctors or by shortcomings in the communication between the Soria and the La Paz hospital? To what extent were the duty judge and subsequently also the Audiencia Nacional required to take into account in the annulment proceedings information that was not available to the duty judge at the time when the auto was issued, such as, for example, the advance directive or the informed consent document signed at Soria Hospital? If the courts were required in the annulment proceedings to take into account information not available to the duty judge when issuing the auto, were they under a legal obligation pursuant to Spanish law to inquire why the applicant's signature was missing on the consent?
Thank you very much, Monsieur le Juge Krenk. Micro.
It's fine. J'aurais deux questions qui s'adressent essentiellement au gouvernement, mais la requérante peut naturellement les rencontrer si elle le souhaite. Le droit espagnol permet aux individus de procéder à des déclarations anticipées. En l'espèce, la requérante a procédé à une telle déclaration au terme de laquelle elle a indiqué s'opposer à toute transfusion de sang dans toutes les situations. Dans sa décision du 15 octobre 2018, la Cour d'appel a jugé que ces directives ne trouvaient pas à s'appliquer dès lors que Mme Pindo Mulla était apte à donner librement son consentement. Dans ses observations écrites, le gouvernement semble remettre en cause cette affirmation, notamment aux paragraphes 81 et 82. Ma question est dès lors la suivante, c'est une question qui vise à clarifier. Le gouvernement considère-t-il devant la Cour que la requérante n'était pas apte à exprimer librement son consentement au moment pertinent? Ma deuxième question porte sur les points suivants. Le gouvernement soutient que l'équipe médicale de l'hôpital La Paz était au courant de la situation de témoins de Jéhovah de la requérante. Mais le gouvernement indique que l'équipe médicale, cette même équipe médicale, ignorait l'existence des directives anticipées de la requérante. Et donc, ma deuxième question vise à savoir comment ce système de déclaration anticipée fonctionne en pratique, comment ces directives sont-elles portées à la connaissance des personnes qui sont appelées à décider? Un registre, si j'ai bien compris, a été mis en place. Qui a accès à ce registre? Comment cet accès s'organise-t-il en pratique? Et est-ce que les médecins de l'hôpital La Paz pouvaient-ils avoir facilement accès au registre des directives anticipées? Dans ces observations écrites, et notamment cela ressort du point 81 des observations écrites du gouvernement devant la Grande Chambre, le gouvernement, mais ça demande justement à être précisé, semble considérer qu'en cas d'urgence, il s'avère en pratique impossible de prendre en compte de telles déclarations anticipées. Je souhaiterais avoir une clarification sur ce point. Enfin, le gouvernement peut-il indiquer à la Cour si le juge de permanence pouvait-il, d'une manière ou d'une autre, solliciter l'accès au registre des directives anticipées avant de prendre sa décision? Je vous remercie.
Merci beaucoup. Judge Niatowski.
Thank you. I have two questions to both parties. The first one would concern the line of behavior of the medical professionals in the case of the applicant. Was it possible, in the party's view, already at the La Paz hospital, for the medical professionals to address the medical condition of the applicant in a way that would save her life whilst respecting her wishes not to be subjected to blood transfusion? And my second question would be sort of a follow-up to the question of Judge Seibert IV, and it would concern the position of the duty judge, whether in the party's view, the duty judge, even if the duty judge didn't have all the elements, were the elements that were available to the duty judge sufficient and necessary for this judge to authorize involuntary treatment of the applicant. And if such necessary and sufficient elements were missing, to whom would the parties attribute the fact that they were missing? Thank you.
Thank you very much. Judge Kitistakis.
Thank you. I want to ask the defendant whether the University Hospital of La Paz provided medical treatment without blood transfusion before the 7th June of 2018. At the time, was this hospital the only one providing such a medical treatment? And if so, can you give us some statistical data of similar medical treatment? And finally, whether in such medical treatment the university hospital always consulted the duty judge, asked the opinion of duty judge, or there was another way to proceed to this specific medical treatment. Thank you.
Thank you very much. Judge Bosniak.
Thank you very much, Madam President. My first question will go a little bit in the similar direction as the question of my colleague, Judge Seibert-Ford. Namely, according to the government, the applicant never challenged actions of the medical doctors at the domestic level. First of all, I would like to hear from the applicant how they comment, how the representatives of the applicant comment this assertion by the government. And then, for both parties in this respect, if true, should this mean that this court should not take into account the actions of medical doctors because they were not challenged domestically, and we should instead focus only on the fact that the duty judge issued the ex parte order. Now, in case we should examine only the ex parte order ordered by the duty judge, shouldn't we nevertheless take into account the application that was made by the medical doctors for issuing that ex parte order? And if so, should we then also assess whether there were any missing or inaccurate information provided by the duty judge and how this possibly affected the order given by the duty judge? Now, my second question relates to my first question. Namely, if to the contrary, the view of the parties is that this court could examine, in the broader sense, the actions of medical doctors in the applicant's case, could the respondent state at all be responsible for actions of those doctors, taking into account the court's views in the case of Lopez de Souza Fernandez and some other cases and some other judgments rendered by the court? My third question is the following one. How does the government comment the applicant's assertion that the doctors at La Paz Hospital had ample opportunities to check the applicant's will regarding the medical treatment, either directly with the applicant or through other alternative channels that were mentioned by the applicant's representatives? And then my fourth question is then similar to the question that was asked by my colleague, Judge Frederic Krenk. Namely, I wonder whether the duty judge had the opportunity to check the applicant's views or positions regarding the medical treatment proposed, more precisely the blood transfusion. Judge Krentz opened the question of possible access to the register of advanced directives, but I wonder whether there were also alternative and other means available to the duty judge to check it within this short period of time available. Thank you very much.
Thank you very much. Judge Moreau-Wikström.
Je vous remercie, Madame la Présidente. Ma question s'adresse principalement aux représentants du gouvernement, mais bien entendu, la requérante peut apporter des observations si elle le souhaite. Comment est-ce que vous définiriez l'état de lucidité, de discernement et la faculté d'interagir de la requérante avec l'équipe médicale pendant le trajet de l'hôpital de la Soria à l'hôpital La Paz, qui a été un trajet, si j'ai bien compris, assez long, de 2 heures, et jusqu'à l'arrivée à La Paz, jusqu'à l'opération à 15 heures. Donc son état, sa lucidité et son discernement. Si on considère que la requérante avait un taux d'hémoglobine qui était sous la barre des 5 grammes par décilitre, ce qui voudrait dire que sa conscience était altérée, alors ma question est simple, elle reprend la question de certains collègues et notamment celle du juge Krenk. Pourquoi ne pas avoir cherché à accéder au registre, à la fois le registre local de Castille-Léon et au registre national, qui sont des recours, si j'ai bien compris, qui sont des registres qui sont ouverts 24 heures et d'accès 24 heures sur 24, 7 jours sur 7. Si cela était difficile dans l'urgence et dans le peu de temps qui était imparti aux médecins, pourquoi ne pas avoir cherché à accéder au consentement anticipé qui était dans tous les documents médicaux? On a parlé de manifestation de volonté de la requérante à 6 reprises. Son refus de transfusion sanguine a été exprimé à 6 reprises, que ce soit oralement ou dans des documents écrits. Deuxième hypothèse, si on considère, et c'est ce que semble dire la requérante, si la patiente était en pleine possession de ses moyens et alors qu'elle a réitéré son refus oral dans l'ambulance, pourquoi ne pas lui avoir fait formaliser un document de consentement éclairé et de refus de transfusion dans l'ambulance ou dès qu'elle est arrivée à l'hôpital de La Paz? Ensuite, la dernière question qui est plus générale et qui s'adresse encore une fois au gouvernement. Quelle est, selon vous, la raison d'être de ces directives anticipées? Quelle est leur force véritable? Qu'est-ce que vous leur reconnaissez comme force véritable dans une situation où il y a un risque de mort évident, un risque de mort qui existe, et face à un patient qui est conscient, qui est déterminé et qui est opposant? Je vous remercie.
Merci beaucoup, Monsieur le juge Pastor Vilanova.
Merci beaucoup, Madame la Présidente. J'ai 3 questions donc à poser aux 2 parties. La première est la suivante. Quels risques, notamment pénaux, encouraient les médecins qui ont traité la requérante à l'hôpital de La Paz s'ils avaient finalement laissé mourir celle-ci? Deuxième question. La défense de la requérante a affirmé aujourd'hui, oralement devant nous, que la requérante voulait vivre, mais refusait la transfusion. Moi, c'est très important, et je demande si c'est le cas de le répéter. Elle voulait vivre, mais ce qu'elle ne voulait surtout pas, c'est être transfusée. Par conséquent, la question qui se pose devant la Cour semble réellement celle de savoir si un patient a droit à un traitement médical particulier pour sauver sa vie. Cette obligation positive a une base conventionnelle? Si oui, laquelle? Et alors, quelle serait alors la marge d'appréciation de l'État? Dernière question, qui est très similaire donc à celle qui a été posée notamment par le juge Bosniak. Le débat sur la possibilité d'un traitement médical alternatif a-t-il eu lieu devant les tribunaux espagnols? Et si ce n'était pas le cas, pourquoi? Je vous remercie.
Merci beaucoup. Judge Alosegui.
Thank you, Madam President. I have several questions. The first one is related to what my colleague, the Judge Fred Krenk, has said, but also having the advantage of knowing the national Spanish legislation, in my case. Then, according to the Spanish law on the rights of patients and according to the Castile and Leon Autonomous Community, the Advanced Medical Directive is sent to the public and private hospitals, and it is annexed to the clinical records of the patient according to the state observations. We have been informed that it's in the Jimena system. Then could you confirm that it was the case in relation to the applicant, Pindo Mulla, that all this information was in this electronic version? Then there was an electronic version available to doctors in the Soria hospital. My question is, it is not the state obligation to transmit this information or the access to it to the Madrid hospital, giving a password or an access to it, because we are in a national territory. And in the request for assistance, there is a telephone conversation from Soria Hospital to the gynecology service of the Madrid hospital. It is not an obligation of coordination of the information of a patient among public hospitals in all the state. My second question is related to the information that an ambulance in Spain has to have about the patient, the protocols, and in concreto the protocol of Castile and Leon. They have to include his or her name and the clinical history of the patient and the informed consent and the advance directives. And in this case, could you explain how can be that the doctors of La Paz, Madrid, asked the duty judge of permission for an adult for a transfusion without including the name of the patient? My third question is, you say in your pleadings before our court that from the beginning, the Soria Hospital, there were this document of the patient refusing blood transfusion in any case with her signature. You say there were not two documents, there were only one, of course. Then why, my question, why this information was not provided to the doctors of Madrid or to the duty judge or to the Audiencia Provincial? My point is there is not an obligation of the state to provide with all these documents to all the persons concerned according to the Spanish legal framework and to ask for them ex officio in a judicial process. Well, then I turn to the applicant, the representative of the applicants. Then my first question is about, now we can have the advantage to have also the applicant here at the room. Then about this document refusing blood transfusion, the government denied that the applicant has asked to the hospital of Soria to provide her with this document. This is a controversial issue among both parties. Then, according to the information that we have received at the beginning in the court, when the applicant applied to this court, it was sent a document without her signature. Then we asked it as ex officio from the court, because that was strange, if you have already signed this document, and then during the process before the court, you asked it again to the hospital, and this document was provided with your signature. Then I want to know if you have really went to the hospital in the first moment to ask for this document in order to be provided to the domestic court, or what happened with that. My second question is about to the representatives, when the applicant went to the Madrid hospital. Now the government in their pleadings said that she did not inform to the Madrid doctors, La Paz doctors, as soon as the applicant arrived to Madrid, and that she didn't want to receive any blood transfusion in any case. My question is, which were the expectations of the applicant after having used all the legal framework, Spanish legal framework, about the fulfillment and application of this Spanish legal framework? It's not what only this moment is a history of the patient's rights, about this informed consent and the advance directives, and after having made use of all legal available law to express her will, is what were her expectations. My third question is if you could also confirm to us that the applicant talked by telephone herself during her way to Madrid. My colleague also has asked about that. taking the advantage that the applicant is here, or just we can have this confirmation. I would like it. And the last question in relation with the applicant's appeal of the duty judge auto in front of the Audiencia Provincial, why it was not asked ex officio the information about the clinical records by the judges or by the prosecutor is related to some questions that my colleagues have posed. Thank you very much.
Thank you very much. Judge Koskolo.
Thank you, Madam President. I would like to come back to a point which was addressed by the applicant and which has been addressed in the submissions that concerns the requirements of form concerning refusal of treatment. We have before us a citation of the domestic law according to which a refusal of treatment has to be recorded in writing. The applicants in their submissions have highlighted the fact that there's a difference between a requirement that the refusal must be recorded in writing and a requirement that it would have to be given in writing. And also in the government's own submissions, it is stated that there has to be a trace écrite regarding refusals of treatment. However, it appears that in the domestic court, the Audiencia Provincial stated that both a consent and refusal of treatment must be given in writing. Now I would like to have the government's comments on this contradiction in the positions regarding the state of domestic law on this point. Thank you.
Judge Kusko-Stadelmeier.
Thank you very much, Madam President. My question is similar to the first question of Judge Seibert IV, and it goes to the applicant. It concerns the focus of her complaint at the domestic level. The applicant's position at the domestic level was that the harm she had suffered was the authorization of the blood transfusion, and she calls it a legal harm. Now, before this court, and you have repeated it today, she heavily also complains about the doctor's conduct, for example, that they did not verify the applicant's will, that they did not speak with the applicant, they did not consult the proper documents, they did not provide sufficient documents and information to the duty judge, and they did not envisage alternative treatment. I assume it was not possible to raise such criticism in the appeal against the decision of the duty judge. So my question, why did the applicants not undertake any legal action to impugn the hospital's or the doctor's actions and omissions in order to establish liability towards her for their alleged failures? Was such legal action against the hospital, the doctors, or perhaps the state, because it was a public hospital, for example, a civil action not available? Or was it a deliberate decision of the applicant to only challenge the decision of the duty judge? Thank you very much.
Thank you very much. Judge Ravarani.
Il y a une seule question qui fait un peu la suite de ma collègue. Quel est le statut des deux hôpitaux? Est-ce que c'est un statut public ou un statut privé? Et quel est le statut du personnel médical, et en particulier des médecins qui y travaillent? Est-ce qu'ils relèvent d'un statut public ou d'un statut privé? Et quelle est leur, disons aussi, leur responsabilité? Est-ce que leurs actions engagent une responsabilité publique ou une responsabilité privée? Merci.
Merci beaucoup. I have no additional question, but I do have a request, particularly to the applicants, that when responding to the questions of Judge Seibert IV, Bosniak, and Kushko-Stadelmeier on remedies that were used and available, that you clarify the nature and scope of the applicant's constitutional complaint, which we know was summarily dismissed. The court will now withdraw for approximately 30 minutes, reconvening at 11:25. The parties will then be able to submit brief submissions in reply to each other's submissions and also reply to the questions of the judges. As you have seen, we have numerous questions. Many of those questions are linked. So as the judges have cross-referred to each other, I would also encourage you to group your responses in order to facilitate your task, but also ours. Thank you very much.
La Cour.
The hearing is resumed. We provided the parties at their request with additional time to prepare for the answers to the questions and the reply. I draw your attention to the fact that the judges will have the possibility, after hearing the answers to your questions, to ask for clarifications concerning those answers. They won't, however, pose any new questions. You both have 15 minutes to reply. So I call on the Spanish government.
Thank you very much. First, will take the floor Mr. Francisco Reynoso, who is head of the anesthesiologist department of La Paz Hospital, for the medical aspects.
Thank you very much. Thank you. Good morning. Regarding the level of lucidity of the patient, I would like to point out that being aware and oriented is not a white or black phenomenon, but rather a grey scale. There are several levels of consciousness between a fully awake or conscious patient and a patient who does not respond or is in coma. A typical example may be people taking central nervous system depressant agents. They may still seem conscious and oriented, but they must not drive a car, operate heavy machinery, or sign very important legal documents. It happens exactly the same when there is a lack of oxygen to the brain of the patients due to the very low hemoglobin levels, like 6 grams per deciliter. In these situations, the brain does not work properly, especially regarding the upper cognitive functions necessary for being able to decide with total autonomy. It is very difficult, from a clinical point of view, to accurately evaluate this level of consciousness in a few minutes, especially when we have the experience that some patients can change his or her opinion in the last moment. Regarding the urgency of the case, it is also very difficult to point out a critical level of hemoglobin due to the bleeding, because there is an important inter-individual variability due to the different capacity of adaptation of the human body. This adaptive capacity will then depend on the age and previous physical condition of patients, and more importantly, on the speed and magnitude of bleeding. Obviously, massive bleedings exceed the compensation capacity even in very young and healthy patients. Despite anecdotal cases, it is considered that hemoglobin values below 7 grams per deciliter requires an immediate transfusion. Values below 6 can cause a lack of oxygen to the tissues that are associated with sequelae, and values below 5, they suppose an imminent danger of death. In cases of important bleeding, of active, very active bleedings, doctors must quickly anticipate the transfusion to avoid the falling below these critical levels. You can believe me that this case was really a very extreme and a very complicated and severe life-threatening situation. Regarding the 4 hours of time to preparing the patients, I would like to inform that the physicians on duty that day were attending also other patients in the operating room or intensive care unit during the entire morning and afternoon, because we have a very important clinical charge in the emergency department room of my hospital. Both hospitals, La Paz Hospital and Soria Hospital, are public hospitals, and physicians working in them in these hospitals are civil workers. In all the cases when we have a patient that refuses or rejects a blood transfusion, we always inform to the duty judge. Also, physicians offer the treatment required by the patients, the treatment required by the patient, but only if this treatment is clinically indicated, obviously. And finally, the Hospital La Paz is not the only hospital that avoids blood transfusions, but in this case, and in most of the cases, the patient and other patients prefer our hospital due to the gut results that we have with this. And unfortunately, we, as far as I know, we have not a statistic regarding the number of patients who refuse blood transfusion that are treated in my hospital and in comparative with other hospitals of my country. Thank you very much.
Thank you very much, Mr. Bresnes. You can proceed.
Thank you, Madam President, judges. I will address some of the answers, trying to pick them together, and afterwards my colleague will address other of the questions. First of all, I would like to reply very briefly to the Council's intervention, addressing that they insist in contesting all what happened after the judge authorization, taking into account that this was not revised by courts. Regarding, they say, what Miss Pindo Mulla should have said to the La Paz Hospital. I just clarify, said. She never said, since her arrival to Hospital La Paz, nor showed any documentary evidence from her rejectal, mainly because of her state of lucidity, probably. Regarding the Court of Appeal revision of the authorization of the duty judge, we have to very precisely say that the task of the appeal court is just to revise something that happened before Ms. Pindo Mulla arrived to La Paz Hospital. Therefore, any comment on the lucidity of the patient, of the applicant, is just an obiter dicta pronouncement. Nothing had to be with the lucidity of the patient when she had to take or not the decision, when she had to be or not informed of the treatment when she arrived to La Paz. Therefore, that judgment has to be taken into consideration in its precise limits. Finally, and also I would like to say that it is very easy to issue medical reports some years after things have happened in a comfortable office, saying what urgency teams should or not should have done in very, very delicate situations, even entering in these reports into subjective aspects as to whether Mrs. Pindo Mulla was or not lucid, or whether she had or not expressed her rejection, which are factual aspects that haven't been contested before the courts, and it is not for experts to testify or give testimony. Regarding the question of Judge Selbert Forth, remedies available to the applicants against La Paz Hospital, I want to separate for what they did. In fact, the applicant could have prosecuted or complained for an injury crime at the criminal level, at the criminal courts, and could have also issued or sued for a non-pecuniary damages against her integrity because of a treatment not accepted treatment. But in the other case, in case they had let her die, which is another of the questions, they could have brought proceedings against the doctors or even to the La Paz Hospital as a public administration. A criminal liability for imprudent homicide because of commission by omission, which is a specific category in Spanish criminal code. And also, they could have started patrimonial liability for malpractice, medical malpractice, through either administrative or civil claims, which would be revised either by contentious administrative jurisdiction or civil jurisdiction against doctors and even the hospital just at the contentious administrative level, because it is a public administration, who could repeat again or claim against the doctors if the hospital should have paid something or some indemnization for the applicant. Regarding the question on which basis the auto could have been annulled, to what extent were the duty judge required to take into account information not available, we have to take into account that the duty judge could only take into account the information she had at that moment. In a very urgent situation, she consulted the forensic doctor and the public prosecutor, and with that, she issued a simple authorization which simply authorized medical services, urgency services of La Paz to do anything needed for saving the life of the patient, but leaving or giving leave to assess, when the patient arrived to the hospital, her lucidity and the need to do that treatment, because she was transferred not to do a blood transfusion or a hysterectomy, sorry for the word, I can't pronounce it, but to evaluate alternative treatments. But she worsened, her state of health worsened during the trip, so they had to take that decision very quickly. On Judge Crank, Mr. Reynoso has already spoken. She had not full lucidity when she arrived because of the hemoglobin data that he has offered. She was 4.8 or afterwards 5.5, always under 7 level of hemoglobin, which is the status he has already stated as the minimum status to have a lucid consciousness. In case of emergency, should they have been impossible to take into account directives, emergency in this case impeded for the emergency unit, as he has already addressed, dedicated to save many patients, to consult an advance directive that was not in her medical charter. When the medical charter arrived to La Paz, the advance directive was not there, and the previous rejection signs were not there. Regarding the advance directive system, my colleague will address afterwards. Regarding the question, was the duty judge, were the elements he had sufficient to issue that authorization? If they were missing, who is responsible? Responsible, dear judges, is time and urgency. Is they responsible for taking a decision so quickly for a so urgent situation? About just Bosnak question, should this mean that the Grand Chamber should not take into account the lex artis and just the duty judge because of the applicant's lawyers only having contested before the national courts the judicial issue process and not the medical aspects? We understand that what it can't be discussed now is the medical lex artis, nor the evaluation of the lucid of consciousness, because none of those aspects have been contested, and the national courts have not had the opportunity to revise it due to the subsidiary principle, and many judgments of the court insist on these points. So the Grand Chamber is not in a position to evaluate this. But if the Grand Chamber considers to enter the facts, in any case the facts, they have to evaluate the facts, the statement of facts we have presented based on the medical direct contact with the patient and not the facts presented by the counsel of the applicants. I would like to add that the duty judge could she have called to the ambulance. We have to say that a simple call from a judge to a person in an ambulance does not allow per se a personal check sufficiently valid to evaluate her lucidity or consciousness, taking into account the difficult procedures are stated in our law in order to have a complete proof of the real will of a person. It is not compatible that a simple call would have been enough for the duty judge to know the real will of the patient. Regarding the question of Pastor Villanova, did this debate take place in the Spanish court or of alternative treatments or not? This aspect was not challenged before the courts. Now my colleague will address the rest of the questions I haven't addressed. Thank you very much for your attention.
Thank you very much, Ms. Nicolas Martinez. And just to remind you, you do have relatively limited time.
Thank you. Apology if any response is missing, and we are at your disposal to answer all the clarifications or complementary responses we don't sufficiently answer. About the fact that the applicant didn't submit the signed informed consent duly signed. It was at her disposal. Honorable Judge Elosegui has stated that it is a disputed fact whether she had required the document or not to Soria Hospital. The reality is that she did not. They only say they requested this access, but they don't submit any document that supports this allegation. And we do provide a certificate issued by the registry in Soria Hospital stating that no access request was submitted in 2018. So it was at her disposal. She didn't ask for it, so she didn't submit it at the appeal court. Why didn't she do it? We don't know. It's probably a question of negligence or not having the due diligence to take into account or to see that the document they were filing was not complete, and the Court of Appeal didn't have to act ex officio because the rules of the procedure are so. Is this the appellant who has to provide the document in support? About the fact that the rejection of a treatment must be in writing, we refer to Article 2 of Law 41/2002 of Autonomy of the Patient, which expressly says this: the refusal to treatment must be in writing. Nevertheless, the problem here, or the reason who determined that she received a blood transfusion was not that there was not a refusal in writing. There was not a refusal in writing, and there was not a refusal orally. At the moment she arrived at La Paz Hospital, she didn't mention at any moment the fact that she refused blood transfusions. She didn't show this supposed document that she was carrying in her purse, to which the applicant's counsel has referred. If she had it, she didn't show it. And she didn't even mention the existence of an advanced medical directive. Regarding the advanced medical directive system, we have been asked how this system works, and we can provide further information or a document explaining in further detail the way as it works. We can now say in a brief manner that the National Registry makes a task of coordination of all the autonomous community registries. In this case, so a person, a doctor who has access to the registry in one of the autonomous communities would have a link to another, the registry of another autonomous community. The judge could have fast access to this registry. For that purpose, the judge would have had to send an order to the competent authority to get this information. In the context of absolute emergency, where the facts went, it wouldn't have been time enough to do all of these steps. I would like to make a last mention about the issue of the medical paternalism, to which so much importance gives the applicant's counsel. In Spain, there is not a problem structural of paternalism in the medical field. The applicant's counsel doesn't even say that expressly. And even the third intervention from the Jehovah's Witnesses Association makes a thorough study of the legislation and practice in all the countries in the research, and doesn't find any fault from the part of the Spanish law or practice in this field. But what's more, in Spain, the authorities always took into account the will of the patient. In the moment in the hospital of Soria, she said she was a Jehovah's Witness and refused blood transfusions. Several months before the facts of 7th of June of 2018, the treatment who was applied to her was always in accordance to her beliefs, and it was prescribed a special treatment which wouldn't have been prescribed to another patient which didn't have this condition. At the moment that in Soria Hospital, they found that the only way to save her life there was to make a blood transfusion, they accepted they wouldn't operate her. And they facilitated her to get into contact with another hospital in Spain where she could have the possibility to have assessed the assessment of the possibility of another alternative treatment. And that's what they did. Judge Elosegui has asked if there is an obligation of coordination between hospitals. There is not such an obligation. The different autonomous communities make an effort to have a cooperative relationship, and the Hospital of La Paz was asked by Hospital of Soria if they would accept this patient without any obligation. They accepted this, and they put all the resources, material and personal, to that end, and intensive care ambulance with a doctor in it were put at the disposal of the applicant to facilitate her the possibility of assessing another alternative treatment that could save her life. What endly it wasn't possible because the situation in which she arrived to Hospital of La Paz. And finally, regarding the name of the patient, it is true, and it can be striking that in the decision of the duty judge, it is not stated which is the name of the patient. But really, it is important. Is it a relevant information that the doctors need to convey to the judge, or the judge needs to know to make an assessment, a full assessment of the situation with the information they have? We believe not. So the name of the patient was missing, but we don't think that it is something that must affect to the assessment or the correction of the judge of the duty judge. Thank you.
Thank you very much to the Spanish government, Mr. Mutzny or Brady. I don't know which of you would like to take the floor, Mr. Brady.
Thank you, Madam President, honourable judges. I would just like to begin by referring or responding to a couple of comments of my colleagues on the other side of the Spanish government. words or expressions like this was an absolute emergency or her condition was getting worse. Respectfully submit where in the medical records, the contemporaneous medical records, does the court or the government find those expressions? We've gone at pains, we respectfully submit, to take the court to the contemporaneous medical records on the day of, and those expressions are not found in the contemporaneous medical records the day of. There's been a discussion about whether a refusal of treatment needs to be in writing or not for it to be legally effective, and we've already referred to Article 2.4 of the national law. But in addition, if I could direct the court's attention, to the healthcare law of the autonomous region. This is at page 247 of our materials. The materials that we filed with the Grand Chamber, 247. This is Article or Law 8/2003 of 8 April. And there's a provision, Article 33 under informed consent, Article 33 sub 3, which specifically says when it is not possible to obtain prior written consent, it shall be obtained orally. It shall be obtained orally before at least 2 independent witnesses who shall avow to it in writing. We submit that's a common sense provision, is that if there are certain circumstances where, for whatever reason, it can't be in writing, well, there is a provision, and this is informed consent, not refusal, but informed consent, that it can be given in writing. So it's just simply not correct, we submit, to assert that a refusal has to always be in writing or consent always has to be in writing for it to be legally effective. I'll turn now to some of the questions of the judges, starting with Judge Kasakis as far as whether this was the only cooperative hospital. My colleagues on the other side have already answered it's not. In fact, I'm informed that there are many hospitals in Spain that provide treatment to Jehovah's Witnesses without transfusions. Turning to the question of Judge Ganaski, whether the applicant could have been treated without blood transfusions, the answer to that is yes. And we rely on the expert opinion, to illustrate that, of Professor Zakharowski. We've given extracts in the material before the court today, but if I could direct the court to pages 227 to 230 of the materials we filed with the Grand Chamber. This is specifically paragraphs 32 onwards of Professor Zakharowski's opinion. And specifically, Professor Zakharowski, starting at paragraph 34 and 35, he makes an important point that the hysterectomy that was imposed on the applicant, there was never any discussion with the applicant at all, at any time, about hysterectomy. She had only consented to one treatment, and I'll come to that in a moment. She'd consented to uterine artery embolization, a minimally invasive procedure to prevent further bleeding. That was the reason why she was going from the Soraya Hospital to the La Paz Hospital, not because Soraya couldn't provide any treatment, but rather it was to provide her access to what she agreed to, uterine artery embolization. And Professor Zakharowski says that would have been the better treatment, minimally invasive, wouldn't have required blood transfusions at all. But he goes on to say even with hysterectomy, the applicant could have been managed safely without transfusions, and he gives all of the recommended procedures using patient blood management, the World Health Organization standard. And these are, even with a blood loss, using a cell saver. So during the operation, she lost 1.2 liters of blood. Professor Zakharowski says that it was mandatory that they should have had a cell saver to recover that blood and give it back to her, her own blood. And he concludes, had they had that essential procedure that they should have had, and they had ample time, hours to prepare, there would have been, he concludes, there would have been no medical requirement at all for transfusions. But the La Paz doctors approached it without even talking to the applicant, with what they wanted to impose on her, as if she wasn't even a party to the proceedings or party to the medical procedure.
Could I remind you, we have all of the annexes, we have the full expert report. It would be more useful if you could answer the questions posed by the judges.
Thank you. Turning to the question of Judge Moore Wickstrom, and this relates to an issue that's come up, whether the applicant was lucid or not on the day on June 7th. I think the simple answer to that we submit is that issue was never raised in the domestic proceedings. It was never a question. It was never questioned that she was anything but lucid. There's not a reference at all in the medical records about that. And specifically, as far as the audience provinciale, the page 108, the Court of Appeal confirms twice. And I think it's important to turn to the actual language of the Court of Appeal. 108, this is of our materials, where the court says, right at the top of the page, it is clear that the applicant could freely express her will at the time of the surgery. Parenthetical, it does not appear otherwise from the proceedings. And at the bottom of the same page, it is on record that the appellant at the time of the intervention could decide freely whether to have the blood transfusions or to refuse it. It's only been raised for the first time here, whether she was lucid. It was not raised anywhere else. And for good reason, because the doctors who actually assessed her were of the view that she was capable and conscious. And there's been a lot of talk about a hemoglobin level of 4.7 grams per liter. And to remind the court, the document in the extracts that we have before the court, page 8, is the opinion or the notes of the consulting hematologist who saw her on the morning of June 8th at the Sarai Hospital when her hemoglobin was 4.7 grams per liter. And he writes, after noting her hemoglobin was 4.7, the patients, for religious reasons, Jehovah's Witnesses do not wish to be transfused under any circumstances. And importantly, the next point, I inform the patient of the possible vital severity in case, in any circumstances, the bleeding worsens again, and she consciously refuses any transfusion. She consciously refuses any transfusion. Well, we've just heard from the representative of the government that everyone is different. Everyone reacts to a blood loss differently. But we don't have to guess about Ms. Pindo Mulla. We have the doctor who treated her on the day of, looking at her, speaking to her, and confirming she had the capacity. She consciously refused transfusions under any circumstances. And finally, on this point, if I may, we've now heard for the first time today that a hemoglobin level under 7 grams per liter affects cognitive disability, or cognitive ability, rather. Where is that in any of the material before the court? In the chamber, for the first time, it was raised that, well, maybe a cognitive or a hemoglobin level of 5. Maybe that's where there may be an effect on cognitive ability. But even that, as we've argued, and I'll give the reference for the court, in our February 3rd, 2022 reply at paragraph 12, we deal with that at some length because the government is relying on a document that looked retrospectively at 9 people who weren't patients. It wasn't even a peer-reviewed medical study. That was the highest you could put it. It was not a consensus opinion of the medical community, even at 5. And then finally, Judge Eluxe asked 3 questions. The first is, when did the applicant ask for the informed consent document? And the answer to that we submit is in the materials, again, the submissions to the Grand Chamber. We provided the key documents that we before the Chamber, and the key document I'd like to take you to is page 192. This is a statement, a sworn statement of the applicant that was provided to the Chamber, and she explains when she made the request for the informed consent document. And if I could just read, it's one paragraph. The explanation is as follows. In 2018, when I formally began to process my appeal, I asked the patient care service at the Santa Barbara Hospital in Soraya, the Soraya Hospital, for my medical reports, including the informed consent documents that I signed on June 6th, stipulating my refusal to accept blood transfusions. In reply to my request in 2018, the document that I was given included the aforementioned informed consent document, but without my signature. The document only included the signature of the treating gynecologist. Since I specifically remembered signing the document, I once again returned to the patient care service on 4 February 2020. That was prior to the application being lodged with the court, to request that I be given the document, the copy of the document that I had signed. After providing proof of my identity, and she goes on, the hospital now provided her, and lo and behold, now it had the two signatures. So the point we respectfully submit from that is the applicant did all that she reasonably could. She went to the hospital in 2018, asked for the document, and she was given a document which had only her signature. But in the domestic proceeding, she consistently said she had signed the document as well, and it's confirmed in the hospital records, as we saw in the extracts on page 9, where the treating gynecologist says, well, yes, the patient, of course, did sign the informed consent document. The second question was, why did the applicant not inform the La Paz doctors that she had refused blood transfusions? We submit the answer to that question is it's important for the court to put itself in the applicant's shoes. Because at this time, the applicant, and if I could take you to the records, page 9, this is the document of the treating gynecologist, who after noting, this is on June 7th, after noting that the applicant refused transfusions, that informed consent document was signed, importantly is what the document continues to say. Given the clinical situation and the impossibility of performing blood transfusions, it was decided to transfer to the referral hospital for what? With interventional radiology to assess uterine artery embolization treatment. And the applicant, she addresses that same point in her statement to the Constitutional Court. This is at page 15, right in the middle of the page. She says, by mutual agreement, we decided, she and the gynecologist, that I would be transferred to La Paz to receive quality medical treatment without transfusions. So when she was put in the ambulance, when she agreed to be put in the ambulance, she understood one thing. She was going there for uterine artery embolization without transfusions, a minimally invasive procedure that's safer, according to the experts, has shorter recovery times, and has a 16 to 25% lower risk of death. I mean, that's what she understood. She did not understand that they were going to give her a hysterectomy and impose a transfusion on her. So when she arrived at the La Paz hospital, she felt safe and secure because the whole purpose in being there was for her to be respected. Had she understood that that wasn't going to happen, there was a change, well, it's obvious she would have said no in the loudest and clearest of terms, but the duty was on the doctors to have told her if there was a change in the treatment agreement, they had the duty to have had that discussion with the applicant. And finally, the question is, did the La Paz doctors speak with the applicant by telephone? And the answer to that question we submit is, again, at page 182 of the materials that we filed with the Grand Chamber. And this is the interview with the applicant by the applicant's counsel. And she answers at page 182, during the transfer, could you explain what happened? And she answers, of course, because even while I was going to Madrid during the transfer by ambulance, the doctor from the hospital in Madrid called me about my position to prepare for the surgery. Then I made my position clear. I even took the document the doctor gave me from Soraya, and I took it with me. She brought the documents with her. So the applicant clearly said that when she was transferred, a phone call was made, She spoke herself with the La Paz doctors in the ambulance, page 182 of the materials. My colleague will address the remaining questions.
Thank you very much, Mr. Musni.
Madam President, honorable judges, I try to condense the questions. So there was one common question by judges Kuksov-Meyer, Bochniak, and Zieber related, could the applicant have brought proceedings against Soraya and La Paz doctors, for instance, for medical negligence, civilly or criminally liable? To answer that question, you have to understand that everything starts with an ex parte order, when Ms. Pindo does not even know about. Everything starts with that duty judge order. So after she comes to know about this decision, she has to make a choice. She contacts a lawyer and she asks for advice. And the advice she receives after long consultation by several lawyers is that, yes, theoretically, it is possible to bring an action for medical negligence against the doctors. However, only theoretically and not practically. Why? But simply because the doctors received a court order that was protecting them. That was a protective wall for them, and the lawyers considered that because of that order, she would hardly succeed in bringing an action for medical negligence by against the doctors, because the judge was backing her up. And there is another point that also may tip the balance in going the direction they went, was simply because the main issue at stake, and that's an issue that is and that remains before your Grand Chamber, and that's why we are here before the Grand Chamber, it's an issue of principle. The issue of principle, which is a constitutional issue, which is a conventional issue. Can a competent adult patient be forced to a medical treatment against her will? This is a constitutional issue, and that's why this issue went to the Constitutional Court for an imparo recourse based on Articles 15 and 16 of the Constitution. And behind this question, there might be also a question, had Ms. Pindo and her lawyers exhausted all the remedies? And the answer is clearly yes, because your court has stated in many cases, for instance, Grand Chamber Aquilina versus Malta, that if more than one potentially effective remedy is available, then the applicant is only required to use one of these. And the Constitutional Court recourse was an effective remedy in this case. And that relates to the second question by the Judge Gniatowski about the extent of the actions of the duty judge. Was it the appropriate procedure? Was there enough means and, I would say, competence for the duty judge, even on reconsideration, to address all the issues, all the factual issues that we are now trying to address here? Well, yes. Article 315, paragraph 2 of the Procedural Criminal Code of Spain clearly shows that the duty judge, the judge, has an obligation, a duty of diligence to determine exactly what is the situation. And especially when it is such a serious issue as here, where there is a violation or alleged violation of bodily integrity. So the judge was, and this is what was normally expected from him, to determine the identity of the patient. That's a basic thing for a judge, to determine what is exactly the medical situation of the patient. Is she in a medical emergency? Is there an alternative treatment for her? And all these answers were just one call away. In our modern society, when I hear the government saying that, no, it's simply not possible procedurally to make that call, well, then a patient is in the hands of doctors who can do what they want. This is simply not possible. The judge was, in these circumstances, just a rubber stamp. That was the role of the judge. And the judge had the prosecutor, she had the forensic doctor who were there, who could also do the work try to investigate, to determine the situation. This is too serious just to leave it and to blindly trust the doctor's determination. So that's why Ms. Pindo went through that course, and that relates also to the third question of Judge Radharani, if I remember well, about what was the scope of the constitutional recourse. And you mentioned that also, President O'Leary. Well, the scope is obviously to determine whether there was a violation of her constitutional rights to self-determination and freedom of religion and conscience, which is that's the main question. But if you look at pages 120 of our annex and following, the appeal to the Constitutional Court, the applicant has raised all the factual points there. She has made that clear that she was in full possession all times of her intellectual, volition, mental capacities, that we argue here that she had made that her will known crystal clear so many times, that the doctors in La Paz knew about her will, that there was no discussion about her lucidity, that it is even addressed the point, what does it mean to record the will of the patient in writing. All these aspects are clearly discussed and developed here over many pages. And the Constitutional Court had the possibility to address that, but it simply summarily rejected it. We don't know why, but the points are there. So there was ample opportunity all throughout the domestic procedure, or the course of domestic procedure, for the domestic courts to resolve, to address this issue. And actually, what happened here when we went to the court, to the European Court, we went here with a principal question, the one I raised from the beginning. And it's only because the Chamber posed several additional questions related to the alternative medical treatments, to whether it was a life-threatening situation, that we got into that specific discussion, which was not our purpose at first. Because whatever life-threatening circumstances, whatever emergency, the main point is to determine whether Ms. Pindo had clearly expressed her will, that's the case, whether she was fully mentally competent, and she was, and whether her will was respected. You have that in Haas versus Switzerland, paragraph 54, or on many occasions, several occasions also in Arskaya versus Ukraine. This is the main issue for you to determine. I'm moving now to the next question from Judge Per Villanova. What were the criminal risks for doctors if they were to respect the will of the patient and, as a consequence, she were to die? Well, as a matter of principle, a physician, a doctor, cannot be prosecuted for respecting, or cannot be certainly not convicted for respecting the clearly expressed wishes of a patient. And I refer you to page 10 of the third-party intervener, the European Association of Jehovah's Witnesses, which mentions a long list of cases in Italy, in Poland, in Canada, where it clearly states that doctors do not incur civil or criminal liability for respecting the patient's wishes. And that's all logical. On the contrary, a physician may incur criminal or civil liability, depending on the circumstances, for violating the patient's bodily integrity. I just would like to mention one point, but I will do it with a second question from Judge Pastor Villanova. Did the applicant raise the medical issue about the alternatives existing? Well, yes. If you have a look at the annex, you see that both on appeal and before the Constitutional Court, the applicant has briefly addressed the issue of medical alternatives. But again, this is not the main issue. This is a subsidiary issue, as we just mentioned. What is at stake is determining the validity of a refusal to undergo a medical treatment by a patient in his or her decision-making capacity. And there is not a problem here because Ms. Pindo's will was crystal clear. And if there was a doubt, and I'm coming to what the government is saying about was she lucid, he was not sure, probably not, there was one simple thing to do. Ms. Pindo is here. She was there. They could have asked her. They could have tried to determine whether she was truly conscious. Those who did it, the doctors in Soraya, the first doctor, the second doctor, the doctor in the ambulance, they did it. And with what conclusion they come to? They come with a clear conclusion: she's conscious, orientated. Conscious, orientated. She has full capacity. Glasgow 15 out of 15. The last question I will address from also Judge Pastor Villanova is patient entitled to a specific treatment to save her life. The patient, and I would like to turn it the other way around, which is the case here, the patient is entitled to have his or her will respected. That's what the patient is entitled to. To respect the will of the patient to be treated according to her wishes. This is not an outstanding treatment. This is not a special occasion. This is the heart of any medical relationship between the patient and the doctor. Everything starts with that. The patient is the core party of the situation. And I would like to move out of the issue of blood transfusion because unfortunately sometimes there is still some prejudice and stereotypes related to that treatment that Jehovah's Witnesses might decide to die, which is absolutely not the case. If a patient refuses a chemotherapy and wants an alternative treatment, and we use the same principle, can he be forced or can she be forced because the doctor sees no other alternative to it? Obviously not. The will of the patient will be respected in any situation. And why? Well, first reason is because a doctor, especially in a public hospital, is a service provider. Like us, lawyers, we are service providers. We provide an advice to a client. If the client disagrees, we might try to convince our client, but we will never force our position on our client because we are service provider. And the same applies to doctors. And the second point is, and I would like just to illustrate that, Ms. Pindo was transferred from Soraya to La Paz. She didn't know at all what was taking place behind her back. But imagine that at some point during the ambulance transfer or she arrives to La Paz Hospital, she comes to know that there was an ex parte order authorizing doctors to treat her against her will, as they wish. Well, I'm sure she would have jumped. She would have screamed. She might have even called the police. But imagine that the doctor comes to her and tells her, Madame, I might be criminally prosecuted if I don't try to save your life at all costs. So I will take you, I will handcuff you, I will sedate you, and I will treat you according to my will. This is absurd, isn't it? Or maybe the doctor might say, oh, there is a public health policy here where I need to protect any patient at all costs. So I will sedate you and I will treat you according to my will. Or I don't have any alternative treatment available to treat you differently from what you asked me for. I'm sorry, but I have to force you, I have to sedate you, I have to force a treatment upon you. That's the main case. That's our issue here. And that's what you have to determine. Do we want to live in a society in Europe, within the Council of Europe, where such situations are possible? I hope not. Thank you.
Thank you very much for your submissions. Do any of the judges wish to ask for clarifications of the responses provided to their questions? Judge Pere Pastor Villanova.
Merci beaucoup, Madame la Présidente. Une dernière question adressée au requérant et qui est compliquée mais simple à la fois. Est-ce que la requérante était prête à mourir en 2017, faute de transfusion? Merci.
Merci beaucoup. If there are no further requests for clarification, I would like to follow up on the response provided to the question of Judge Christakis. He asked whether the duty judge is routinely requested, and the advisor from La Paz indicated that in the event of a refusal of blood transfusion, I understood you to say that the duty judge is always requested. So my question is, does the duty judge either ask the doctors or himself or herself seek to access the registry, or do they ask the doctors for the provision of information from the transferring hospital? Because, of course, there are two situations. One is a La Paz patient who remains in La Paz with the medical records available to the duty judges requesting the duty judge to intervene. Another is a patient being transferred from one autonomous region to another. And the government has emphasised that the system is decentralised. But of course, the legislation on consent and the advanced medical directives is applicable throughout the territory of Spain, as far as I've understood. So you have two requests for clarification, one for the applicant and one for the Spanish government. The applicant may proceed as the government prepares their response.
Thank you. I appreciate your question, Judge Pastor Villanova. Obviously I cannot answer instead of Ms. Pindo, but what I can tell you is the evidence available. And the evidence available, you'll find it at page 1 of the binder we provided to you. I am one of Jehovah's Witnesses, and I do not accept transfusions of whole blood, red cells, white cells, platelet, or plasma under any circumstances, even if healthcare providers feel that such are necessary to preserve my life. This has been her consistent position right from the start, all throughout her life. This is not tantamount to suicide. She wanted to live. She wants to live. That's the situation. But obviously, in any treatment situation, for her or for like any other patient, the consequences are uncertain, and we don't know what can happen. But the problem is not the treatment, is not the refusal of blood transfusion that kills a patient. As the Supreme Court of Chile has made that clear, the problem comes from an accident, from an illness that can happen to any one of us. The refusal of a certain treatment or the alternative treatment is just a personal choice, whatever the consequences. Hopefully they can be positive. Sometimes they can lead to fatal consequences. Ms. Pindo was ready to face whatever the consequences. What she was not ready to face is to force a treatment against her will.
Thank you very much. I now call on the advisor of the Spanish government.
Thank you. Regarding your question, it is important to point that usually in La Paz Hospital, we communicate with the duty judge and we give all the medical information, all the social information, all the psychosocial information that we have available in order to help the judge in the decision. In my experience, in some cases, very similar cases, the judge, after the information, decides to follow the will of the patient. And in some cases, very similar to this, in our hospital, with the experience and the knowledge of the patient in our hospital that we transfer to the judge, the judge has decided in the direction of following and respect the decision of the patient. In this exceptional case, it was very difficult to give additional information to the judge, to the duty judge, because we don't know any information regarding very few information that gave through a telephonic call to the gynecologist. We have a very little information regarding the patient. So this little information regarding the patient was transferred in this case, in this special case, to the judge. But it is not the usual, contrary to that. Okay?
Thank you very much for the further clarifications provided. We've now come to the end of the hearing. I thank the parties for their submissions and their answers to the Court's questions. The Court will now deliberate on the admissibility and merits of the case, and the judgment will be pronounced at a later stage. The parties will be informed of the delivery date. I declare the hearing closed.